Yes, Your Lordship, on our part, we are ready to proceed. We have, just for purposes of record, filed a set of submissions on behalf of the applicants. They filed on 1st of August 2019. We also filed a list of authorities our list of authorities, Your Lordship, runs to 378 pages, filed on 1st of August 2019, same day. The request for 1 hour for the applicant's team. We can share that out 1 hour amongst council on record for the applicants. We're ready to proceed.
Thank you. So I have seen yourselves and Mr. Soka share some, that is the third and the fourth, isn't it?
Yes.
But let us also share.
Yes, it is true. We share.
Yeah. So the time that you share will also belong to Mr. Soka. So all of you divide the time amongst yourselves.
So the 1 hour we can.
And then Mr. Joroge also shares another client with Professor Ojeda.
Yes, that's true.
And is that not? Do you have that? No, use fourth and fifth. Huh? Yeah. So you will agree because I know you all of you want to speak. So if Professor you speak for 20 minutes, the balance of the time will be shared amongst the rest of the applicants.
Yes, I'm likely to do about 40.
It is up to you.
40.
For me, I want a candid and a timely timekeeper. Rose, are you up to the task? You must be. If you need assistance from another court clerk, we can call for one.
Due to the to the weight of the issues before you, can we at least ask for 1.5 hours?
Okay, how many of these persons do we have? In the original how many were there?
There are 11.
There are 11, eh?
Yeah, 10.
So I believe all of you standing there will be representing the fifth persons across the board.
It's true.
Yeah, so where you do not share is the only one that I can allocate specific time for the applicant. Do we have any counsel representing a client who is not shared by other advocates?
Yes, of course. The first accused person is not shared.
It's not
Second
shared.
accused person is not shared. The 9th, 10th accused persons are not shared.
And they belong to your side?
Yes, they belong to
your side. Belong to your side, eh? Let me do this to be as fair as possible. I'll give the entire team of the applicants 1 hour and 15 minutes. I will top up the 15 minutes in the respect of those who are not shared. Mr. Ojeda, you are the lead counsel. If you take the 30 minutes, it's okay. Then what you do, you agree amongst the rest of you how much time each one of you have to take. And I also reiterate, it's not necessary for each one of you to speak. If one counsel has already spoken, then you do not need to repeat the same thing.
It's true.
I think the clients are saying that really you have similar mindset.
Yes.
Isn't it?
It's okay.
So you agree amongst yourselves. As you agree, let me go to the prosecution team.
Yes, Madam.
Mr. Moteti?
Yes.
How much can you give?
I think we'll be comfortable with 1 hour on our side, and we have agreed only 2 of us will address them.
I see that you also had filed some.
Yes, we've filed grounds and authorities.
1 hour?
Yes.
So for you, the team is not large, you are 4?
Yes.
You can agree to share the time.
Much obliged.
But then just before, I think on behalf of this, the 4th, 5th, and 11th, we did find a list of authorities. We qualified a list of documents, which we qualified with the comments of my colleagues. We needed some time to basically elucidate and what we are finding.
But are those plans not also shared by the professor's team?
They're shared in a different way, because I believe the professor is most of the documents will be just the first time.
Why would he? But he represents also the other council.
Yeah, but now the kind of documents in the file will need to be elucidated by us who are filing.
Are they different from the ones that he has filed?
Yes, a bit different.
Okay.
Yeah.
And Mr. Jorobi?
Yes, we had also equally filed our list of authorities.
Do you deviate from what Professor Tim
Yes, we'll
submitted
deviate,
in court?
we'll deviate a bit from his team in the issue of amounts in the charge sheet and also the unique circumstances of the third accused.
Yeah, we know that it drops to more than 5
But
minutes.
yes, we will not take more than 5
Yeah,
minutes.
so what are you deviating from, Mr. Swaka? But I want us to manage the time properly.
We have issues with this, other than just the issue of bail reduction. Some of the orders or conditions that were touched.
It is okay.
Yeah.
So what you do, Professor and your team, let me give you 5 minutes. Agree on how you're going to share that 1.5 hours. If it is necessary, I can add each one of you extra 10 minutes. But first of all, share the time equally, or however you think you should share it. Then for the purposes of Mr. Jorobi and Mr. Swaka, I will top them up each with 10 minutes.
Thank you, that's okay.
Yeah, so you agree?
Most grateful.
Yeah. Agree. So for the purpose of 1.5 hours,
Yes.
agree how much time you have. And then you must also flow from you are the lead counsel, Mr. Harvey will top up, and then for the others, the balance of the time. So when you rise to speak, Mr. Jorobi will start before you come. You'll be the last. I'll give you an extra 10 minutes. I will give him an extra 10 minutes.
Thank you, madam.
Yeah. So you agree, just 5 minutes and then we
That's fine.
That's enough.
Yeah, I have no other matter proceeding to tell me your matter. So we will see you in 5 or 7 minutes.
Most questions.
You can step outside and get this matter.
Most questions.
Revision 34 2019, Henry Rotich and 2 others.
My lady, in the matter, my name is Waititu. For the applicant, yes. My lady, the matter emanates from
Is the respondent the accused person?
the respondent should be the accused persons, accused number 9 and 10, who are Italian companies. My lady, allow me to point out to a unique fact in the matter that before our letter asking for revision, the file had been forwarded to you by an order of the trial court in a ruling dated 29th July. So that our application, yes, so that within that trial file, the court had asked that the High Court looks into the proceedings of that day as far as the main issue, which is the advocate having taken plea on behalf of the companies, was concerned. So that our letter is a follow-up on that request by the trial court.
What I need to know is just the application file, the revision application file that came together with the original file.
Yes.
Number 2, if you have the date for that file, is good, so that I'll place this matter on the same date that we have the other matter. Because we cannot be able to call for the lower court file, which is already called for in another similar matter.
No, my lady, my understanding is within the trial court file, the file in which plea was taken, the court made an order, but no revision file was opened. So that the revision file is this one before you.
Okay, so there's no other revision
There's
file.
no other revision
then
file.
What we shall do is to
Yes.
call for the record.
That's fine.
Isn't it?
Yes.
So what is the urgency now that we are doing the vacation one?
My lady, the urgency is that whether or not the matter will proceed depends on whether or not these two accused persons who are Italians will take plea, or whether or not the plea taken by
They
their
will take
counsel.
plea on behalf of the companies.
Yes.
So are they the sole directors of the company?
Sorry, my lady. To make you understand, the counsel on record, Mr. Anami, had purportedly taken plea on behalf of these two companies. which we had an issue with. And so the court said, if you have an issue, let me forward it to the High Court to see if it was correct.
Okay. So on its own volition?
Yes.
Okay, that's okay. Was there a letter written by the court?
No, just its order,
Okay.
the court's order.
They should have written a letter. Nevertheless, we'll avast ourselves with the orders that were made.
All right.
And then we can satisfy ourselves. So, pursuant to that order, what exactly do you want? Pursuant to the order of the learned magistrate, now that you have the revision filed.
What we are asking the court is to agree with that, with our argument before the trial court, that it was not proper for the council to take plea on behalf of the companies. And my lady, we are seeking that you could apply section 365 and just apply your mind to it and give us a ruling without...
No, I can't do that. I have to satisfy myself that that is the correct record.
Yes.
The original file.
That's
Once I do that,
yes.
then we will proceed. We may have to object, cancel the took plea, or who was directed to take plea, and then I do a ruling.
That's fine. I'll be guided. All right. Sorry, my lady. I am advised by my senior here that I need to indicate to the court that the lower court matter is meant for mention on Wednesday, so that maybe if the file were to be called,
What is the purpose of the motion?
the mention is for compliance. Yes. So the court will take into account that fact.
Did I get it correctly that the compliance is the taking of the process of the taking of plea?
No. The compliance is as far as disclosure is concerned, documents and pre-trial. Yes.
So what was plea taken?
Plea was already taken.
Okay.
Yes.
Even as directed
Yes.
by counsel on
Yes.
behalf of the company?
Yes.
Okay. Then I don't think there's any urgency because just the pre-trial would not affect the hearing of the revision application. Yeah, if it were the process of plea, then I would stop the proceedings. Yeah, so I'll just give you a date. So you need to serve this application.
We shall.
propose give a date next week. We have before the duty judge on the 13th of this month. I've directed that the deputy registrar calls for the trial, record of proceedings, but that should be done after the 7th, after the pre-trial conference has taken place.
We must apply.
Call them. Those are digital clocks or what is viewers. So cumulatively, all the applicants council will get 1 hour 15 minutes, but with additional 10 minutes each from Mr. Joroge and Mr. Swaka. Is that fine?
Yes.
So how you, so if you take all the 1 hour 15 minutes, your team shuts up. Then I'll go straight to Mr. Swaka and Mr. Joroge, each to submit for 10 minutes. Okay?
It's okay.
Yeah, so we'll do the colonial style. Once your 10 clocks, you hit the table and then you sit.
The problem is that... Are you taking a break for 5 minutes or do we start? Well, you had said you...
If you are ready, we are starting. The 5 minutes was for yourself to talk and agree on time.
It's all right.
So I'm ready.
Thank you.
Ready?
Yes. So, yes. My turn says 11:12.
It's 11:12. Your Lordship, before you...
Yes, and I'm not a fast writer.
Oh, I will be very temperate.
Yeah.
Before you, Your Ladyship, is a revision commenced by way of a letter under section 362 of the Criminal Procedure Code, and which revision, Your Ladyship, sets out a number of grounds upon which the first, second, third to seventh, 8th and 9th applicants seek a revision of the bond terms given by the Honorable Mr. Lawrence Mugambi in anti-corruption case number 22 of 2019, Republic versus Honorable Ferdinand Waititu Babayao and 12 others, and which terms, Your Ladyship, set out bond terms for the accused persons as follows. Your Ladyship, it is important that I restate the terms as set out by the lower court for purposes intended under section 362 of the CPC. For the first, third, and fourth accused persons,
And fourth.
yes, first, third, and fourth accused persons, that is for Ferdinand Waititu, Zachary and Jenga Mbugwa, and Joyce Gina. The court directed that each deposits 15 million shillings cash bill or a bond, supplied bond with surety of 30 million Kenyan shillings. Yes, Your Ladyship, just for the record, it is first, third, and fourth. That is the first, Ferdinand Waititu, third, Zakaria Njenga, sorry, Luka Mwangi is the third, fourth is Charles Chege Mbudia. The third and fourth are here. They're both here in court. Yes, Your Ladyship, for purposes of the clarity of record, the first accused person faced charges in criminal case number 22 of 2019 in count 1 and which count relates to a sum acquiring an interest in a sum of Kenya shillings 25,624,500,000
Kenya shillings again?
25 million 624,500,000 and two other counts, Your Ladyship. I just want to be clear. Your Ladyship, it is important, I'm submitting on this line just to relate the charges with which the first accused person was charged, so that the court is clear on the sums in question. The first count, Your Ladyship, stated that while governor of Kiambu County, he acquired a direct interest to wit a sum of Kenya shillings 25,624,500 in respect of payments made to Testimony Enterprises Limited for contracts awarded to the said Testimony Enterprises Limited by Kiambu County. That's count 1. The other count that touches on the first accused person, Your Ladyship, is count number 2, count number 2. I believe the charge sheet is on record, Your Lordship. Count number 2, Your Lordship, relates to a sum of 18,410,500. He was charged that between 2nd July and 13th March 2019, he received 18,410,000 from Testimony Enterprises Limited, a company where he is a director, having reason to believe the same was acquired from Kiambu County. So those are 2 counts of 18 million and 25 million. The third count, Your Ladyship, is at count number 3, where the first accused person is accused or charged with a sum of Kenyan shillings 7,214,000 shillings. And again, the charge is that on diverse dates in 2018 to 3rd January 2019, while again a director of Bienvenue Delta Limited, he received 7,214,000 from Testimony Enterprises Limited, which sum is believed to have been acquired from Kiambu County through another company. Your Ladyship, the total sum for which the accused person is charged amounts to Kenya shillings 51,200,000 shillings. And that is instructive, Your Ladyship, in setting bond terms. It is oft said, and it is now within the media, that the first accused person acquired or stole directly from Kiambu County, which statement is first and foremost incorrect as per the charges framed before the court. And this needs to come out clearly, Your Ladyship. And for a charge of acquiring a sum of 51,500,000 shillings, the first accused person was placed on bond terms of 30 million Kenya shillings and cash bail of 15 million Kenya shillings. So this should be the first line of submission, that bond term is excessive. And Your Ladyship, at an appropriate time, I will submit on what I will term as judicial chaos. It is no longer the obedience of the now well set out bail and bond policy that guides the courts in granting bond, but the discretion of the trial magistrate. And that discretion is now prone to occasional and erratic abuse by the lower court and the trial magistrates. Your Ladyship, in now the famous Aror and Kimwarer dams case, where the minister, Aror and Kimwarer dams case is number...
So you see that the discretion is being...
The discretion is basically is now there is flagrant abuse of discretion by the lower courts. Your Lordship, this is anti-corruption case number 21 or 20, Aurora and Kimware Dams case, where
My lady, sorry,
I just want this.
I'm constrained to object to that line of submission.
You can't object. You can't object. This is common knowledge.
The court.
Mr. Muteti,
Yes,
I have
ma'am.
not even heard what he's talking
Yes,
about.
let me say first.
I just had 2 names.
Yes, Aurora.
And Aurora. So
Yes.
what were you going to say? Let me
Okay,
first finish the
let
Yes, let me finish the statement.
Then you get the context. Then you can make your objection.
Your Lordship, in a similar charge, in anti-corruption economic
That
crimes
is number?
case, number 21 of 2019, Republic versus Henry Rotich, the Minister for Finance, and others, a charge was brought against the minister, and the accusation is misappropriation or illegal irregular payment of 63 billion Kenya shillings. Similar bond terms were given, 15 million. How do we... Let me-
Hold on. $63
63 billion Kenya shillings. He was given bond terms of 15 million by Ogoti, by the Chief Magistrate, Mr. Ogoti. Similar bond terms. The first accused person faces similar bond terms in a charge where the total sum for which is accused is 51,200,000 shillings. The origin of our submission is this: that is sufficient ground for this court to disturb those bond terms as not only being excessive, but as being irrational, unconscionable, and nowadays, Your Ladyship, it has come to a point where the person appearing before the court, and depending on which court you appear before, Your Ladyship, your bond terms will vary. It is no longer a question of the previous decisions made by this court. And I want to demonstrate, Your Ladyship, that in a near similar case, we have cited this at page 29 of our submission, the case of Professor Mohammed Abdallah Swazuri and 23 others versus Republic, where the accused persons were facing charges and claims of irregular payment of over 100 million Kenyan shillings. This court varied bond terms from Kenya shillings 12 million to 7 million. In our list of authorities, we have annexed the Swazuri case. It is marked as FNW 20 at page 334 of our list of authorities. Your Lordship, in the same vein, in anti-corruption case number 32 of 2018, Republic versus Evans Kidero and 10 others, where the accused persons face a charge of Kenya shillings 213 million, still for hearing before Mr. Goti, Chief Magistrate. The court granted bond terms of between 5 million shillings for the first accused person to 2 million shillings for the other accused persons. Your Honor will find the decision at page 326 of the list of authorities. Your Honor will note that the variation, it is no longer clear what guides courts in granting bond and or the option of cash bail. We seem to have moved too quickly to the days of equity, when the length of the foot of the magistrate determines the terms of bond or cash bail granted to accused persons. And your Ladyship, the High Court has not been helpful in settling this question. And I wish to refer to the very decision in Rogers, Nzioka, and 10 others versus Republic. Which is at page 3 or 5 of our list of authorities. In Rogers, Nzioka, your Ladyship, Justice Edwin Omudi set out the terms that define bail under Article 49(1)H and Section 123 of the Criminal Procedure Code. And those terms include, your Ladyship, the consideration by the court whether an accused person is a flight risk, the gravity of the offense and its impact, any character or antecedents or associations of the accused person, including whether an accused person has previously jumped bail. And, your Ladyship, the court then set out that the prosecution must satisfy the court through an affidavit if the accused person is likely to breach any of those terms. Those conditions, Your Honor, have continued to prescribe or to guide the courts, but often, Your Honor, with variation from court to court. Because even after the Rogers Nzioka decision was made by the court, and you refer to it, Your Honor, the courts have continued to invariably apply these terms. And depending on what court you appear before, Your Honor, you will find that the terms of bail will vary, even where the charges are near similar. Your Honor, we submit that 15 million shillings as cash bail for for the first accused person, for the third and fourth accused persons is harsh. And even for the third and fourth accused persons, where the charges are set out in the charge sheet, relate to the performance of a contract of Kenya shillings, 588 million Kenya shillings, Your Honor, Your Ladyship. The sum of Kenya shillings 15 million is still excessive. Your Ladyship, let me demonstrate further absurdity.